10 USCIS and DHS immigration changes to know before August 31st. June and July didn't just bring heat, they brought real immigration policy shifts. From USCIS rule changes to IC enforcement crackdowns, from visa application traps to citizenship delays, everything is moving fast. This isn't just news. It's your life, your family, your status. These are the 10 updates you must know before August 31st. This is BorderDrip USA. Let's get into it. 1. Green Card Medical Exam Rule tightened, effective June 11. Let's start with a technical update that could quietly sabotage thousands of green card applications. As of June 11th, Form I-693 medical exams are no longer transferable once your I-485 is closed. USCIS will now reject any previously submitted I-693 form if your adjustment case is denied, withdrawn, or resubmitted later. Even if it's still within the 2-year validity period, if your case isn't active, your medical isn't valid. This means added costs, potential delays, and full retesting, even for simple vaccine records. Key points. I-693 is valid only while your I-485 remains pending. Withdrawn, denied, or reopened cases require a fresh medical exam. Delays can mean restarting TB tests, vaccines, and lab fees. 2. USCIS must now disclose negative evidence, effective June 12th. For once, a win for transparency. On June 12th, USCIS formalized a policy that requires officers to disclose derogatory or negative information before denying a benefit. This means if your case is at risk due to past issues, like a visa overstay, past arrest, or conflicting records, they must now let you know. You get a chance to clarify, respond, or submit proof before a denial is issued. This new standard applies to work visa extensions, green card renewals, and even naturalization cases. Key points. Officers must reveal damaging records or findings before denial. Applicants get a chance to respond or submit clarifying documents. Applies to multiple case types including I-130, I-765, H-1B, and more. 3. SIJS work permits and protection revoked, announced June, impact ongoing. This was one of the most heartbreaking changes from June. Thousands of undocumented youth with special immigrant juvenile status, SIJS, lost their protection and their work permits. When USCIS ended deferred action for pending SIJS cases, these are minors who were abused, neglected, or abandoned, and many are now at risk of deportation. Their only protection had been a temporary status that allowed them to live and work legally while waiting for green card processing. That's gone now. A lawsuit has been filed, but as of now, protections have ended. Key points. Deferred action and EADs revoked for SIJS applicants. Thousands of youth lost legal status overnight. Class action lawsuit is ongoing, but protections not restored yet. 4. TPS terminated for Honduras and Nicaragua, confirmed July 7. A major rollback from DHS came in July. Temporary protected status, TPS, for Honduras and Nicaragua is officially ending. The final termination is set for July 5, 2025, and affected individuals must now take immediate action, apply for another legal status, or prepare to leave. There is no automatic pathway to residency, and without TPS, deportation becomes an active risk. Many of these individuals have lived in the U.S. for over 20 years. That won't matter under the new rules. Key points. TPS ends July 5, 2025, for Honduras and Nicaragua. No direct transition to green cards or residency. Deportation becomes likely if no alternate relief is secured. 5. Social media vetting now required for student and exchange visas, started late June. In late June, DHS activated a new vetting requirement for all applicants under the F, M, and J visa categories. If you're applying for a student or exchange visitor visa, you must now submit your social media usernames for the last 5 years. Officers will screen not only your public posts, but also engagement, location tags, and any concerning behavior. Even a meme, a controversial like, or an unrelated tweet can delay your approval. Key points. Mandatory disclosure of social media handles for student/exchange visas. Applies retroactively to 5 years of online activity. Officers may use posts to question visa eligibility. 6. New fees announced for asylum seekers, confirmed July 11. For the first time in U.S. history, applying for asylum now comes with an annual fee. USCIS will charge $100 per year to process ongoing asylum cases, and a proposed rule may increase that to $200 per year in the next round of enforcement. This is part of the H.R. One Big Beautiful Bill signed into law earlier this summer. If your asylum case is pending 3 years, that's $300. No payment equals no movement. Key points. New $100 per year fee for asylum applicants effective July 2025. Applies even while waiting for interview or court. Future immigration benefits may also include fees under H.R. 1. 7. USCIS changed its official text notification number, July 1st. If you rely on text messages to get USCIS updates, pay close attention. Starting July 1st, the official USCIS SMS number changed from 468 to 311 to a new short code, 872 to 466 USCIS. If you ignore these texts thinking they're spam, you could miss biometrics, RFE deadlines, interview notices, or even denials. Key points. Official USCIS text alerts now come from 872 to 466 USCIS. Old number 468 to 311 is no longer in use. Missing messages could cost you your case. 8. ICE ends bond hearings for many detained immigrants. Policy shift. July 8th. This July, ICE quietly ended bond hearings for many undocumented immigrants who cross the border or overstay their visas. Under this change, immigrants may be detained indefinitely without bond, unless their case qualifies for an exemption. That means no bail, no hearings, no chance for supervised release. Legal groups are already preparing lawsuits, but for now, it's in effect. Key points. Bond hearings eliminated for many undocumented immigrants. No chance to request release or pay bond. Rule applies even to asylum seekers in expedited removal. 9. Extra H-2B visas issued for 2025, announced July. Here's a bit of practical relief for employers. USCIS confirmed that supplemental H-2B non-agricultural work visas will be issued in waves for the remainder of fiscal year 2025. This is in response to record labor shortages across hospitality, landscaping, and construction sectors. Employers can now file for additional workers outside the regular cap, especially if they can prove urgent seasonal demand. Key points. DHS expanded FY25 H-2B visa quota mid-July. Applies to seasonal employers in high-need sectors. A limited-time opportunity. Allocations are first come, first served. 10. USCIS leadership change plus policy shifts, mid-July. In mid-July, President Trump's new pick Joseph Edlow was confirmed as the new director of USCIS. Edlow's confirmation is already leading to internal shifts in how applications are handled. USCIS also updated guidance for T visas, U visas, and VAWA self-petitioners, making it harder to qualify without strong documented evidence. Expect stricter adjudication, more RFEs, and a push to streamline enforcement coordination with ICE. Key points. Joseph Edlow confirmed as new USCIS director. Policy updates already issued for trafficking and victim relief categories. Stricter document verification and fewer second chances. Bonus policy. Disability exception for citizenship now harder. Revised June 13th. A final update for those seeking citizenship with medical disability exceptions. On June 13th, USCIS revised how it evaluates Form N-648 used by applicants unable to meet English or civics test requirements due to medical conditions. Now, doctors must provide much more detail, including how the condition specifically affects memory, language processing, and long-term cognition. Cases with vague or generic diagnoses are being denied. Key points. N-648 now requires in-depth medical explanation. USCIS may reject based on lack of specific cognitive proof. Form revisions emphasize fraud prevention and strict evidence. Final thoughts. These aren't rumors. These aren't predictions. These are real, approved, or already active policy changes across June and July 2025. From I-693 medical traps to SIJS youth being left unprotected to asylum applicants being charged, the immigration system is shifting fast under the Trump administration. Don't assume your case is safe. These changes impact green cards, asylum, naturalization, TPS, and even student visas. Before August 31st, take time to verify your documents. Track any policy updates related to your category. Consult an immigration attorney if your case is in limbo. That's your full BorderDrip USA breakdown. Everything you need to know before August 31st, 2025. If this helped you or someone you love, don't forget to hit like, subscribe, and turn on the bell. Drop a comment. We answer real questions with real updates. Thanks for watching, and as always, stay prepared.